Finally, some exciting testimony in the Michelle Troconis trial. We've been waiting for days and days, listening to DNA experts, and it's just been really, really boring. Nothing too exciting going on. Well, finally, after day 19, we've had 2 days of testimony by Pawel Gumienny. I think that's how you pronounce his name. Pawel Gumienny, who was one of the project managers for Fotis Duelis, and he took the stand for 2 days, and some very interesting developments happened throughout the case. Now, again, we don't have a roadmap for this case. There's no opening statement, so we don't really know yet which pieces of information are actually going to be important once the entire picture is created by the prosecution. But definitely, we're starting to see some things take shape. So we're going to get into that in just 1 minute. But first, we did have a little bit some testimony of a social worker who was assigned to be the supervisor. As we recall, Fotis was required to have a supervisor who was supervising his visitation with his children at that point. And there was some discussions which, as we've seen this trial kind of play out, we see kind of what some of the arguments may become. And one of the arguments when it came to a lot of the DNA testings and DNA samples that came back as positive to Fotis, it seemed that the defense was actually going to make some suggestions that literally just a few days before, or maybe it was even the day before the disappearance of Jennifer Duelis, Fotis Duelis was actually at the house visiting the children, and of course was under the supervisor. The supervisor was there at the time, and they were eating, but they were eating outside of Jennifer Duelis's house. And there was some DNA from Fotis found inside the house. So how did that get there? And part of what it seemed that the defense was starting to argue, at least what we were able to tell by some of the comments that were made, is that it's possible that Fotis's DNA got on some of the materials inside the house, not because he actually came and murdered Jennifer and was in the house trying to clean it up, but the reason why is because maybe he had some contact with Jennifer, maybe some hair fell off of him onto Jennifer, maybe he touched Jennifer, maybe they shook hands, maybe they hugged even, and then some of that DNA somehow got transferred from him to Jennifer, and then from Jennifer to, let's say, the sink, the handle in the sink, or some other places in the house where it's possible Fotis's DNA could end up. Doesn't necessarily mean that he was there committing a murder. That was kind of the seeds that I've sensed that the defense is planting, and therefore the prosecution called the supervisor and asked this social worker who was appointed by the court to supervise the visitations. She was asked, was there any contact between Fotis and Jennifer? And the only contact that it seems that there may have been is that there was some cake that he gave her to put in the fridge, and there was also some chocolate that he ripped off, a little bit piece of chocolate, and gave it to Jennifer. So that seems to have been the only possible way that DNA would have transferred. There was Fotis never went in the house. That's what the supervisor said. He never went in the house, and therefore this kind of makes it a much harder argument for the defense to argue that Fotis somehow got into the house during that visit, or some of his DNA got into the house because of that visit, because really there was very, very little interaction between Fotis and Jennifer, and how would his DNA end up on the sink and things like that. So that would be very tough. So that also, I think, was an important part to point out. So let's get into Pawel Gumienny's testimony. Before we do, I want to play a clip, which is just great because it really gets into hearsay, and really just this interaction. This interaction actually went on for many more minutes afterwards because the jury was excused, and then there was a proffer, and then there was more argument about this. So we're not going to play the entire 25 minutes, but I'm going to play just where this all begins, and then I'm going to kind of fill you in on everything that happened afterwards and explain everything like we always do, so you'll understand the law and understand the rules of evidence that they're discussing, and we'll see who was really right in this argument. So without any further ado, let's play that clip that occurred. And just to give you a little bit of context, what's going on here is that Pawel Gumienny is on the stand, and he's saying something that he heard Fotis tell him. Now, just to lay a little bit of more of a foundation here before we get into the actual clip, a party opponent's statement is admissible. It's, even though it could be technically hearsay, it is admissible because it's a party opponent. So here, the defendant's statements would be allowed in. So anytime they say, "What did Michelle Troconis tell you?" there's not going to be an objection for hearsay because it's a party opponent statement and it can come in. So you'll never hear an objection. Maybe you will from this attorney, but you generally speaking, that's admissible. But here, Fotis, his statement, he's not a defendant. So his statement should be classic hearsay. And really, there's two problems with his comments. Number one, it's hearsay. And number two, it can violate the confrontation clause of the Sixth Amendment. What's the confrontation clause of the Sixth Amendment? It really goes back to the famous case called Crawford, which essentially says the following. You can't introduce a testimonial statement by somebody who is not going to be subject to cross-examination. So if you have the defendant sitting at the table and this case is going on, and then somehow a statement, let's say it falls into an exception of hearsay, even if it falls into the exception of hearsay. But if that person's statement that's coming in now cannot be cross-examined, or there was never an opportunity to cross-examine that person about that statement, then that statement cannot come in. It violates the Sixth Amendment, the Confrontation Clause, which provides that each person is able, any defendant is able to confront the witnesses that are testifying against him. So therefore, if there's any, again, testimonial statement made by anybody who is not available to come in for cross-examination, that would violate the Sixth Amendment, the Confrontation Clause. Okay, so we're going to jump into a little bit more about all this stuff in a minute, but first, let's play the clip.
What's Mr. Doulos saying to Mr. Zeisler?
He's showing
hearsay. If I may, Judge, this is not being offered for its truth. Rather, it's being offered to show the apparent concern that Mr. Doulos had over Jennifer potentially having cameras. So I'm not offering it to prove the truth of the matter asserted, but merely the fact that he was concerned that she had cameras is what's probative in this case.
The problem, of course, is what Mr. Doulos' internal motive was for making hearsay statements. It's not before the court here through this witness, and therefore it is an inappropriate question of this witness. I will also note that at this point, it's also, because it's hearsay, certainly irrelevant to my client. If this was Mr. Doulos' case, that would be a different story.
As the court knows, we have charged Mr. Doulos with committing the crime of murder, and the defendant is charged with conspiring with him to commit that crime of murder. This is directly probative to that issue, whether or not a conspirator committed an overt act.
Still hearsay in this trial.
Well, first, the court addresses whether it is hearsay. It is hearsay. Now, the next question is whether or not there is an exception. And the court would indicate that under the code, well, first, the court is going to just make clear. Generally, what is the purpose of the hearsay rule? The purpose of the hearsay rule is to keep out of evidence statements or assertions by a declarant that could be considered or would be considered untrustworthy or unreliable. That's the purpose of the hearsay rule. The code has carved out exceptions to the hearsay rule. One of those exceptions is essentially called the residual exception to the hearsay rule. And the residual exception to the hearsay rule requires that the hearsay have indicia of reliability. It doesn't fall within the named exceptions to the hearsay rule, but it stands essentially as somewhat of a catch-all. If there is indicia of reliability, the court may admit it. So counsel, other than simply the charge, what is the indicia of reliability?
Well, Judge, respectfully, I disagree that this is being offered for a hearsay purpose. If I may proffer, the evidence is going to be that Mr. Doulos was asking whether or not a
Well, I'm going
particular
to object to him proffering and answering it when I've objected to the testimony in the first place.
Well, the court's question is, what is the indicia of reliability? That presumes the court has found that this is hearsay. Counsel has stated it's not offered for the truth of the matter asserted. Court does not know what the content of the conversation was. Perhaps the jury needs to be excused.
Yes.
Okay, so again, there's more going on, but first we're going to discuss what the judge talks about, which he talks about the residual or the catch-all hearsay exception. Now, everybody knows that hearsay is one of everybody's favorite topics. It's a very, very large category, and it can cause a lot of people with a lot of confusion, especially once you start getting into the exceptions. So, of course, what we do here is we try to explain everything and break it down, and by the time you walk away from here, you'll know better than most trial attorneys. So, a hearsay, right, an out-of-court statement, and you want to introduce the statement for a specific reason. And there's a number of different exceptions. Well, what happens if you can't get that statement in with any of the standard exceptions? So, for example, excited utterance or state of mind. You're just introducing it to show the state of mind or what action the person took because of that statement. So let's say it doesn't fall into any of these exceptions. So there is what we refer to as the catch-all or the residual hearsay exception rule, which in case you think that you've already mastered all of the exceptions, they throw in one more exception to really throw a big curveball in. And the exception reads the following. I'm taking from the Connecticut Code of Evidence, although this same exception is going to be found in every single rule of evidence. And the exception reads the following. A statement that is not admissible under any of the foregoing exceptions is admissible if the court determines two things. The court should determine two things before it gets into this exception. Number one, there is a reasonable necessity for the admission of the statement. So you have to show that this is an important statement. We need to get this statement in. That's number one. What's number two? Number two, the statement is supported by equivalent guarantees of trustworthiness and reliability that are essential to other evidence admitted under traditional exceptions to the hearsay rule. So this goes back to the fundamentals, which is what the judge was kind of discussing. Because this judge is very thought out. He really explains his rulings, actually, which is something interesting because a lot of times the judges won't. They'll just say overruled or sustained. They won't even explain themselves. This judge actually explains himself, which is very interesting. That's why it's much more educational to watch this trial as opposed to a lot of other trials, because he actually explains himself. So, but sometimes his explanation needs explanation. That's what I'm here for. So, what's the idea that hearsay, why is hearsay not admissible? Well, the reason why hearsay is not admissible is because it's inherently unreliable. I'm testifying about what somebody else told me. It's just not reliable. How can we rely on someone telling me what somebody else told him? It's just unreliable. So if you can figure out a way to make that statement more reliable, so then it could be admitted as one of the hearsay exceptions. So for example, an excited utterance is the person was shocked out of his mind and he just blurted out something. There was not much thought process that the person who said that statement could think of in order to lie, right? It was a natural, excited comment that he made because of a certain situation. So therefore, it's less likely that the person lies because it's just his natural reaction to something. So there you have the idea that that's why it's an exception, because that statement is a little bit more reliable than a standard hearsay exception. when you have someone who's not subject to the perjury of the penalty of perjury, and he's not subject to cross-examination, it's very easy for the person to lie. So it's just unreliable. So how do we get the reliability of that statement? And once you increase the reliability of that statement, so now that statement could possibly come in. So that's where this last residual exception comes in. This last residual exception is that if you can't find any other exception to allow the statement in, and there's a reasonable necessity that this statement should come in. There's a necessity that this statement should come in. We're going to explain that in 1 second. So then the judge can say, well, is there any other equivalent guarantees that this statement has some sort of reliability, and it's not just some random statement that was made? And as you notice, when he asked that question, the prosecutor was quiet. He didn't have he asked this question to the prosecutor, well, under the catch-all, is this admissible? Now the prosecutor argued back that no, this actually it's not considered hearsay, because it's really just being admitted to show something else, to show why that he was concerned, what he was concerned about essentially. Which again, the prosecutor here is not accurate. It is hearsay, and the judge was right. This statement is hearsay. Even if it's being offered for something else, it's still a hearsay statement. So the judge here was right. It's a hearsay statement. You want to admit it under an exception. Now, you could argue that the exception here is to show state of mind, or to show what he's going to be, or to show what he was concerned with, right? That's essentially the same as state of mind, but it is a hearsay exception, right? So first, what this judge is doing is that you have to first identify, is this a hearsay statement or not? And this is, by the way, if you are in law school at this time, and you're asked a question about a hearsay, the hearsay rule, the first thing you should do is say, is this a statement that's hearsay? That's the first question you have to ask yourself. Is this hearsay or not? Now, if it's hearsay, now you get into the second part. Are there any exceptions to allow this hearsay in? So the judge was right that this is hearsay. The prosecutor was wrong. And now the question is if there's any exception. So the judge asked this prosecutor, does it have any catch-all? Is there any this residual exception that's allowed in? And the prosecutor was just quiet. Now, remember we said that there's two reasons why a hearsay exception would be admissible. And this hearsay statement would be admissible under this residual exception rule. And the first one is that there is a reasonable necessity for the admission of this statement. What is a reasonable necessity? So the case law in Connecticut says the following. Reasonable necessity is established by showing that unless the hearsay statement is admitted, the facts it contains may be lost. So the facts that this statement provides, without this statement coming in, it's going to be lost. What's an example of that? Because the declarant is dead. Now, this was a statement that was made by Fotis. Is Fotis dead or alive at the time of this trial? He's dead. So therefore, for the reasonable necessity, it comes in. That prong is satisfied. But then you get to the second prong. Is there any other reasons why this statement is reliable? Now, the Connecticut courts have considered certain factors. And one of the factors it considers is the length of time between the event to which the statement refers or relates and the making of the statement. So how close, how proximal in time was the action and the statement about the action? So that is also something that the courts can consider, that, if someone is talking about something that just happened to him, it just occurred, so then that gives it more reliability. If a year and a half passed when a person's talking about an event that happened a year and a half ago, it's not as reliable. So that is another example. That would be an example of why that something should still have reliability, even though it doesn't fit into any other exception. And it's not exhaustive. So this is something that's really, it's not clear, because most of the time, my experiences, most of the time, and I think most trial attorneys will tell you, is that if you're trying to use this residual exception rule, it's not going to work. The judges don't like to use it. It's like, nothing else helps, so you're going to try to get it in through this residual exception rule. It's just not going to fly. It just usually doesn't happen. In the real world, it doesn't happen. which is why it was interesting that the judge even opened up the door and said, oh, let's see if it falls into this residual exception rule. So that's in terms of this residual exception rule. But is there any other reason why this statement could be admissible? And that's where the other part, which I did not show you, which is a clip later on, but you have to watch the whole next half hour of this video of the trial to see what went on. The next part is it's a statement in the furtherance of, in the course of, or the furtherance of a conspiracy. That's another example of a statement that could come in even though it's technically hearsay. And this falls into the exception, and this is from Connecticut rule, but again, these rules are all over. Every single jurisdiction has the same exact rule, but if you want to look it up in Connecticut Code of Evidence, this is section 8-3, and this is the first hearsay exception, which is a statement by a co-conspirator of a party while the conspiracy is ongoing and in furtherance of the conspiracy. So a statement is allowed in if it's by a co-conspirator. So here you have who's on trial now? Michelle Troconis. Who's the alleged co-conspirator of Michelle Troconis? Fotis Doulos. So now a statement that Fotis Doulos made, if that is in furtherance of the conspiracy, it should be allowed in. And that's what this exception stands for. But there's a very strong caveat. And this caveat is that the statement itself cannot be considered to prove the existence of a conspiracy. So this is where you have to really start splitting the straws here. You have a statement that's in the furtherance of a conspiracy. So here the example, the statement was that Fotis wanted to know about whether there's cameras at Jennifer Doulos' house. Now, why would he want to know about cameras at her house? Well, it must be in the furtherance of this conspiracy to kill her, right? So that statement, which is about whether he wants to know about the cameras at Jennifer Doulos' house, whether she has cameras outside or where they are, that is in furtherance, or certainly an argument can be made that it's in the furtherance of a conspiracy. So that's why there was an argument for the prosecution to allow this in. And this is why the judge said a statement that is in the furtherance of a conspiracy is allowed in. However, a statement to prove that there's a conspiracy, that's not allowed in. So you're not allowed to have, let's say, a co-conspirator statement that says, oh, he said that he got together with Michelle at one night and worked out the whole conspiracy. That's not allowed in. But here's a statement about what he's trying to figure out about the cameras at Jennifer's house. That would be in the furtherance of a conspiracy. But it gets better. You think we're done yet? We're not done yet. It gets better. And that is because the defense attorney here jumped up and he argued that, hold on a minute, there has been no evidence yet that there is any conspiracy at all. So who says that you're just allowed to admit in statements by people that the prosecutor is just referring to as co-conspirators if there's been no evidence at all admitted yet that there's any conspiracy at all? So the defense attorney argues that you can't just allow everybody's statement in that you want and just say, well, they're co-conspirators. Why don't you do that? That's a great trick, a great strategy by the prosecutor. Anytime you want to get a statement in, get that statement in and say, well, they're co-conspirators with the defendant. And then you'll just have everybody's statement come in that you want and say, well, yeah, because they're all co-conspirators together. And then if at the end of the day, at the end of the trial, you don't prove it, okay, well, I guess they're not part of the conspiracy. That's not fair. So the defense attorney argued that you can, even under this exception of the co-conspirator statement, that should not be allowed in. Because you have to first establish some evidence that there is a conspiracy, which was not done yet. And I agree with him. There's been no evidence yet that there's really a conspiracy going on yet. Now, it could be it's going to be coming later, and it could be it's going to be a lot of pieces put together. But at this point of the trial, there really hasn't been much evidence of a conspiracy at all. And for this, the defense quotes a case. And this is exactly what it says. It says it straight out in the case. And it says the following: before such statements may be admitted, the trial judge must make a preliminary determination that there is sufficient evidence, independent evidence, to establish the following. Number one, that a conspiracy existed. Number two, that the conspiracy was still in existence at the time the statement was made. And number three, that the declarations were made in furtherance of the conspiracy. And number four, that both the declarant and the defendant participated in the conspiracy. So there has to be a preliminary determination by the trial judge. And this is something that the judge asked, because the judge didn't seem to be familiar with this case. And this is a Supreme Court. This is a Connecticut Supreme Court case. This is very strong, binding precedent in the state of Connecticut. And the judge asked, how can I make that determination if the jury, who's the fact finder, did not make the determination that there's a conspiracy? Meaning, normally speaking, the judge makes rulings over the law and the jury makes rulings over the facts. So the judge is pointing out here, how can you argue to me that the trial judge has to make a factual determination, a preliminary factual determination that there is a conspiracy here, if that's not the job of the judge? The job of the jury is to decide whether there's a conspiracy or not. So he's essentially asking a question on this holding of this decision. But this decision is absolutely black and white, clear that the trial judge does have to make the determination. And to this, the response to this by the defense attorney was that there does need to be a determination by the judge. And it's not based on such a high burden as beyond a reasonable doubt, because one of the questions that also the judge asked was, if I make a determination that there is at least if I make a preliminary determination that there is enough factual evidence to point to a conspiracy, well, then how can you go and make a motion? It's called a directed motion. After the state rests and finishes its case, the defense always makes a motion for a directed verdict that the state did not prove its case beyond a reasonable doubt. So he's saying, if I have to make that determination now, how is it ever possible for you to be able to make a motion for a directed verdict? And to this, the defense attorney responded, well, it's a different standard. It's a very different standard, because here, the standard, which this case says, is that the preliminary determination has to be by a fair preponderance of the evidence independent of the hearsay utterances. So it has to be a preponderance of the evidence. A preponderance is just a little bit more likely. So if there's enough evidence that points a little bit more likely to a conspiracy than that there wasn't a conspiracy, then the judge can now allow in those statements. But if after the prosecution's done, the judge still feels that there's only a preponderance of the evidence, only that burden was proven, but there's no question that there's reasonable doubt, then the judge can still grant the motion for a directed verdict. So here you have the defense attorney made a strong record, and this may become an appealable issue, because he seems to be dead on, straight right about this, the defense attorney. Even though a lot of people don't like him because he's objecting a lot and he's causing a lot of chaos in the courtroom. But for this specific point, he has a very strong basis for it in Connecticut law. And this statement by Fotis was allowed in. Now, again, there could be other exceptions that this statement was allowed in. As we said, there could be the statement was allowed in because of to show that what Fotis' state of mind was. Why did he care about the cameras? Obviously, his state of mind was on the conspiracy. So you're not admitting the hearsay for the truth of the matter asserted in the hearsay. You're just doing it to show what Fotis' state of mind is, that he cares and he's concerned about the cameras at Jennifer's house. So that is that. Now, this gets to one more issue. See, this is just from a 2-minute conversation between the attorneys and the judge, and it takes a half hour to explain. But that's okay, because now you're going to know it for the rest of your life. The next issue that we have to discuss is the confrontation clause. Because here you've got Fotis saying a statement outside of court, and it is the defense attorney cannot cross-examine Fotis on that statement. So it should violate the confrontation clause. So this was another argument that the defense made, is that even if you want to say that this falls into all the exceptions in the world, but still it violates Michelle Troconis' confrontation clause rights, her Sixth Amendment rights, which guarantee that she's allowed to confront the witnesses that are testifying against her. So she should be able to confront Fotis about this statement, and Fotis is dead. So how does this come in? And there's no exception by the fact that the person's dead. Now, there is an exception about a dying declaration, but that's not what this was. This was happens to be that he died later on. So does this violate the Confrontation Clause or not? And here I'm going to agree with the prosecutor, because the Confrontation Clause is only triggered by a statement that is testimonial in nature. It has to be a testimonial statement, then you have a right to confront that witness. But just any random statement that a person makes, which was not testimonial in nature, it was not in thinking about potential criminal culpability, then it's not considered a testimonial statement. This is just a statement that he was having with another contractor of his. So it wasn't at all made with thinking about any future criminal culpability or anything like that. It was just a random statement. So therefore, since it's not testimonial in nature, it does not violate the Confrontation Clause. So after everything, this statement was allowed in, that Fotis spoke to a contractor, an audiovisual contractor, about the potential that Jennifer Dulos had these videos in up at her house, and that statement was allowed in. Now, the question of whether that was in the furtherance of the conspiracy or not, that, like I said, is, I think the law was on the defense's side. Now let's move into the rest of the trial. So, what did Pawel Gumienny testify about? Well, he said the following: Fotis had 2 dogs. One got sick and needed to be put down, and Fotis was very upset that Jennifer was not allowing the children to come and say goodbye to the dog. And Fotis was in the presence of Michelle, and Pawel was there, and Fotis said to Michelle, "Can you believe that Jennifer won't let the kids come say goodbye to the dog?" And Michelle said that BITCH should be buried right next to this dog. So here you see Michelle saying something about that she wants to murder Jennifer. And the argument obviously back is that this is Michelle, who's girlfriend with Fotis, and Fotis is telling Michelle about all the trouble that Jennifer's causing him. So obviously Michelle is going to be on his side, and Fotis is telling Michelle how horrific and mentally unstable Jennifer is and all that great stuff. So of course Michelle's not going to, Michelle's going to take the side of Fotis and going to say comments like this, and whether she means it or not. So it's not necessarily the fact that she means it. People talk like this all the time. So there you have that. Then he says that he told Fotis not to drive to the Toyota Tacoma. Now remember, the Toyota Tacoma, there were some videos of this Toyota Tacoma driving around, and it's clear that Fotis, Pawel, it was Pawel's car, but he was not driving it around this time. It was pretty clear from his testimony that it was not him behind the wheel. And the suggestion, obviously, is that the person behind that wheel was either Fotis or Michelle driving that Toyota Tacoma around town. And he even told Fotis not to drive it because it had some problems with it. It would leak oil and power steering fluid and things like that. Now, and for some reason, Fotis tells Pawel that he wants him to move his truck. What would normally happen is Pawel would bring his truck, his Toyota Tacoma, to the office, the office was at Fort Jefferson Crossing. There's a few different properties there, so you have to keep them in mind. And that was where that was his main house where he lived with Michelle, and he also had a huge office. It was a 10,000 square foot house. And he brought he would usually drive the Tacoma there, and then he would take one of Fotis's cars, either the Ford Raptor or the Jeep or the Suburban. He'd take one of those cars, and that's where he would go out to his job site, and that's what he was a project manager for. But for some reason, Fotis wanted the Tacoma to be moved right around this murder. He wanted it to be moved to a different house of his, 80 Mountain Spring Road. And it was the first time that Fotis ever asked Pawel to move his Toyota Tacoma away from this office/house to a different property of his. Now, the seats in the Tacoma were a Ford Focus seats. So they weren't original Toyota Tacoma seats. They were Ford Focus seats. And I guess they fit into the car. Now, another thing that he said is that Fotis told Pawel, for whatever reason, that he's going to have a meeting with his divorce lawyer in his office the morning of May 24, 2019. And he said that this was strange. Fotis never told Pawel generally speaking, when he was meeting with his divorce attorney. He was never allowed in the meetings. It was always a quiet closed-door meeting where Pawel was not allowed in. But for some reason, Fotis felt the need to tell Pawel that he was going to be meeting with his divorce attorney on May 24th, 2019. Just so happens to be the day that Jennifer went missing. So that was that. Usually he said that he was only in the office, that Fotis was only in the office on Mondays. And we know that May 24th, 2019 was not a Monday. Now, he also talks about that he couldn't find the keys to the Tacoma, and it was very clear to him that Fotis must have taken the keys or Michelle had the keys. Normally, wherever they kept the keys, he couldn't find the keys. So eventually, he went to 80 Mountain Spring Road, and that's where his Tacoma was parked. And that's where Fotis and Michelle were there, and they were a little surprised that he came at that time. And Fotis had a shaved head for the first time. For some reason, he shaved his head. And Fotis said that they were cleaning up 80 Mountain Spring Road because they were cleaning it up. And the reason for this is that they were having a showing later on. That's what the defense points out. They were going to have a showing the next day, and that's the real reason why they were there cleaning up. But Fotis said that he never recalls ever Michelle coming to a project site to clean it up. Even if it's going to be a showing, he doesn't remember ever Michelle coming to clean up a house. So what's Michelle doing there exactly? And he didn't see any cleaning supplies there either. But he didn't go inside the house. He admitted that he didn't go inside the house. And Michelle had the keys for the Tacoma. And then at some point they get into the grant of immunity. And Pawel was granted immunity by the state attorney. The state attorney granted Pawel immunity. And the reason for this is that we all know that there's a Fifth Amendment right to remain silent. We can't force somebody to say testimony against themselves. So here Pawel knows that he was very close with Fotis, and he was very close with Jennifer, and he was, he very likely could have been incriminating himself by saying certain statements. So he didn't want to say anything. He wanted to invoke his Fifth Amendment rights, and he came up with a deal with the prosecutor that the way to get around the Fifth Amendment is that if the state guarantees his immunity. Now, there's two different types of immunities that are granted in these situations. Number one, there's something called transactional immunity, which is basically full, complete immunity. If you testify, we're never going to charge you with any crime associated with what you're testifying about, which is the fullest, the best type of immunity you can get. And then there's the second type of immunity, which is called use and derivative use immunity. And use and derivative use immunity is that they just can't use your words against you. So anything that leads them to take any action from your words or anything that they learn from your words, they can't use then to prosecute you. But if they have independent evidence against you, then you are allowed to use it. Now it seems to me, and I didn't read the document, but it seems to me that the immunity that Pawel was granted here was full transactional immunity. And they make a point of that. And that's important because the defense obviously is going to be trying to bring up that obviously you were involved with this murder, and this why you're coming out to testify is only because you're granted transactional immunity. So he's going to try to plant seeds into the jury's mind that really Pawel actually was involved in this murder. And he does make some points about that. But they get into that, about this granting of immunity. And then we have Fotis calling Pawel on May 25th, telling him that he has a new phone. Fotis calls him on Tuesday that his attorney said he should write down a timeline from Friday. So Friday was May 24th, and now the next following Tuesday, Fotis tells Pawel he should write down, his attorney told him that Pawel should write down a timeline for where he was on Friday. And he doesn't agree. Pawel does not agree with that. Something else is that he also tells him, don't mention that Michelle had the keys to the Tacoma. For some reason, Michelle had the keys to the Tacoma. He said, leave Michelle out of it. Don't say anything that she had the keys to the Tacoma. Now, there was also a bucket. There was a bucket with a hoodie in the Tacoma that wasn't there before. This is what Pawel testifies, that when he looked into his Toyota Tacoma, he saw this red bucket with a sweatshirt and this hoodie, and it was not there. It was not his. It was not there before, and all of a sudden he sees that there after Fotis is driving around his Tacoma. Now, later on, after Jennifer's already reported missing, and Michelle and her children and her daughter our faces are shown on television, Michelle says to Pawel, I am going to kill that effing bitch when she turns up. because her daughter and her face was plastered all over the televisions. And that's what she said it in response to. So again, and it's not like this is an admission that she's part of this. It's a natural reaction that she obviously has a lot of animus towards Jennifer, and now because of her face is being plastered, and her daughter, so you can understand why someone says, "Oh, I'm going to kill that effing bitch," and that's what she said. And then she said, "I'm going to sue her I'm going to sue the news for posting these pictures," and then at one point he starts asking Fotis because Pawel starts asking Fotis where his truck is, because his truck. After May 24th, he's like, "Where was my truck? Where did you drive it? What were you doing with my truck?" And then it comes back that it got washed. He brings it back, and it's completely washed, and the interior of the truck is completely clean. And he said that never, ever happened before. Fotis never cleaned his truck before, his Toyota Tacoma. All of a sudden, he's cleaning it. And then Fotis offers to buy him a new truck. So what's going on there? He's offering to buy him a new truck? And then at some point he tells Pawel that he should buy new seats for the Tacoma. Get rid of the Ford Focus seats that are in there and buy new seats. And he said, "I'm going to reimburse you." And then he said, "When we're going to talk about this, if I call you about getting these seats, don't call it seats, call it hardware." So he's trying to hide this whole idea about him getting new seats. And at some point, Pawel confronts Fotis about this situation with the seats. He says, "What do you want me to do with these new seats? You want me to get new seats?" And he said that Fotis gets very mad at him. He says, "Just do it. We're not going to talk about it. Just do it. Do what I say. And just listen to me. And I'm not going to get into it. I want to discuss it." But again, it's rubbing him the wrong way. It's running Pawel the wrong way. And then he said, "Fine, I'll switch it for the Porsche seats." And remember, there's a Porsche in a different property. And that's what he does. He takes the Jeep, the white Jeep Cherokee, he drives it to this other location, and that's where he switches the Porsche seats into this Jeep seat, the Jeep, and then he's eventually going to take that to his Toyota Tacoma and put those seats in his Toyota Tacoma. Well, that's when he drives back to the original house and slash office where there was police already there who had a search warrant. And this we heard testimony about a few days ago, that the police stopped him and they saw that he was sweating buckets and he was obviously very busy, and he lied about it. It turns out he said that he was in New Canaan and really he was busy trying to take out these seats from the Porsche, which wasn't so simple. The battery was dead. He had to go back to Fotis and he had to boost the battery in order to move the seats back and transfer them. So he was working really, really hard, and he was sweating buckets in order to get these Porsche seats out of the Porsche and into his Toyota Tacoma. And that's when the search of the Jeep Cherokee happened, and eventually he did switch the Porsche seats into his Toyota Tacoma. Okay. Now on cross-examination, did the defense make any headway here? Did the defense poke any holes into what his argument is? So he said yes. Number one, he said some of these comments that you're saying Michelle said, that I'm going to kill that effing bitch because her daughter and herself were plastered all over the television. Pawel didn't say that right away. He had police interviews also, which were recorded, and he never said that in the interviews. He only decided to say that after he signed this immunity agreement with the prosecutor, and that happened in January 2024. So he pointed that out, that you never mentioned this before. All of a sudden, you're granted immunity, and you're trying to point the finger at Michelle. So that was one thing. He also said the fact that Michelle was moving firewood. He pointed out that Michelle was moving firewood. That firewood, he said there was a fireplace in that house, right? It doesn't necessarily mean that they were going to burn anybody, but they had firewood. And in fact, he actually helped bring firewood into a shed there. So you know very well, Pawel, you know that they had firewood stored there, which they used for firewood for their fireplace. He also said that you wanted to sell your Tacoma for a while. Even before Fotis offered to buy your Tacoma, you were trying to sell it, weren't you? And he was. And he has some searches on Craigslist for new Tacomas. So he was trying to sell the Tacoma. So the fact that Fotis offered to buy it all of a sudden doesn't seem so strange. So that was a point that he made. He also said that there was a time where he claimed that he was at a certain location and there was video evidence showing that he wasn't there. And this is something that he was presented with on cross-examination, you told the police that you were at a certain place at a certain time and you weren't there, were you? And the suggestion here was going to be, well, where do you think you were? You were probably helping out with this murder. So that was another point that he was able to make. He also pointed out that the police tried to threaten him with his status. They said, you have to pick a team, and they said, we'd hate to see this screw up your citizenship. He was holding a green card, I believe it was, so if he's convicted of a crime, it can completely mess up his citizenship. And they were kind of threatening him to go along with what they wanted to do, because it's going to threaten his citizenship. So that was also another part that he brought out. So that was the excitement that happened so far. Again, still things are still developing and becoming a larger picture, and we will see where this continues to lead. But that is the update. You're completely now caught up on everything about the Michelle Troconis case. If you haven't yet by this point, come on, you got to subscribe, like this video, and we will see you next time.